Good afternoon, everyone. My name is Eboni Nelson, and I have the honor of serving as Dean of the University of Connecticut School of Law. On behalf of our faculty, staff, and students and alumni, I welcome you and thank you for attending today's important conversation examining justice in America, legal accountability or the lack thereof following police shootings in the Black community. I also thank our co-sponsors for today's event, the Black Law Students Association and the Diversity Alliance at the University of Connecticut School of Law, the University of Connecticut Office for Diversity and Inclusion, the University of Connecticut Law School Alumni Association, and the George W. Crawford Black Bar Association, as well as the Connecticut Bar Association Policing Task Force, who is a supporter of today's event. I especially thank our distinguished panel of experts for agreeing to participate today. Following my introductions, each panelist will give opening remarks, followed by questions and answers. We want this discussion to be as interactive as possible, so I ask and encourage you to please post your questions for our panelists in the chat, and I will ask them on your behalf. Our first speaker today is Professor Jamelia Morgan. Professor Morgan is a criminal law professor and scholar at UConn School of Law. Her scholarship focuses on issues at the intersections of race, disability, policing, and incarceration. Her current research projects include works on representing clients with disabilities, the enforcement of disorderly conduct laws, policing disability, the development of disability as a legal category, and how law shapes disability as an identity in prison and jail. Prior to joining the faculty at UConn, Professor Morgan was a civil rights litigator at the Abolitionist Law Center and worked to improve prison conditions and to end the use of solitary confinement in Pennsylvania state prisons. In that role, she worked as part of the legal team to draft briefs that secured the removal of a client from solitary confinement after 24 years. From 2015 to 2017, Professor Morgan was an Arthur Lyman Fellow with the ACLU National Prison Project, where she focused on the impact of prisons on individuals with physical disabilities and authored an ACLU report released in January 2017 titled Caged In: Solitary Confinement's Devastating Harm on Prisoners with Disabilities. Following Professor Morgan will be attorney Mike Gustafson, who is the Assistant United States Attorney for the District of Connecticut. Unfortunately, attorney Ndidi Moses is not able to join us today due to a personal matter. Therefore, I thank attorney Gustafson for filling in for her. Attorney Gustafson received his undergraduate degree from Amherst College in 1983 and graduated with his JD from the University of Connecticut School of Law in 1986. Following clerkships with 2 federal judges and experience in private practice, attorney Gustafson joined the United States Attorney's Office in July of 1997. He is currently the coordinator of Project Longevity, a gun violence reduction strategy. He previously served as the first Assistant United States Attorney, Chief of the Criminal Division, and Supervisory Assistant United States Attorney in charge of the Hartford office. Next, we will hear from Professor Colin Miller. Professor Miller is a professor of law and the Associate Dean for Faculty Development at the University of South Carolina School of Law, where he teaches criminal law, criminal adjudication, and evidence. He is also one of the co-hosts of the Undisclosed podcast, which has played an important role in the exonerations of 9 wrongfully convicted individuals. Following Professor Miller will be attorney Lonita Baker. Attorney Baker, who is a member of the legal team representing the family of Breonna Taylor, joined Sam Aguiar's injury attorneys after serving as an assistant Jefferson County attorney for over 6 years. She handles cases involving wrongful death, civil rights violations, insurance bad faith, as well as car, truck, and slip and fall accidents. While at the Jefferson County Attorney's Office, she practiced in the Legislative Services Branch of the Civil Division as a supervising prosecutor in the Criminal Division. Attorney Baker obtained her BA degree in psychology with the minors in sociology and Pan-African studies from the University of Louisville, her JD from the University of Louisville Brandeis School of Law, and her MBA with distinction from the University of Louisville College of Business. And last but not least, we'll hear from attorney Sam Aguiar, who is also a member of the legal team representing Breonna Taylor's family. Attorney Aguiar has been a practicing attorney since 2008. His firm handles civil litigation, and he primarily focuses on catastrophic injury cases, trucking cases, class actions, and civil rights. Attorney Aguiar is a prolific trial attorney and goes to trial more than nearly any other plaintiff's attorney in the state of Kentucky. His accomplishments include obtaining the state's first insurance bad faith class action settlement, the largest civil rights settlement in the state, and a recent $1.2 million verdict for a wrongful police pursuit. He has also been involved in negotiating police reform with the city of Louisville and compelling policy changes within police departments, trucking companies, and insurance companies. Thanks to all of our wonderful panelists for participating today. Professor Morgan, I turn the program over to you.
Thank you so much, Dean Nelson. Thank you all to our co-sponsors for this incredible event. Thank you to my co-panelists for taking the time to join our institution virtually today to talk about this very important issue, and I look forward to the conversation. I will speak for about 5 minutes and hopefully provide a broad framework for thinking about some of the deep and important questions that was posed in the original invitation for this event. Primarily, I want to address the question of what role is there for law in seeking justice for the victims and their families, particularly of state violence and police violence, given our subject matter for today. And then two, offer some thoughts on the question of can the law be used as a tool to transform policing in America for the better? And so perhaps it's not surprising given my background and my presence on a law school campus, but I agree that there is definitely a role for law to play in working to repair and redress the harms experienced by victims and their families. But I think what I want to do in the brief time I have is to expand how we think about the law and legal accountability and accountability period in this moment. So there's front end accountability, and I think that the local movements going on in Minneapolis, Seattle, Los Angeles, and in our own community here in Hartford suggest that there's ways for contesting and seeking justice that are focused on preventing pathways to harm or creating conditions that avoid police encounters, confrontations, and violence in general. So I'm thinking of the efforts at the local level to, scrutinize police budgets, to look at changing the role that police have in responding to things like mental health crisis, laws that are looking to amend the terms of the collective bargaining agreements in various cities. And so I think of those types of accountability as sort of front end accountabilities, again, trying to on the front end structure and change the nature of policing in a community and reduce potential pathways to police violence. I imagine that many of us on the call today will talk about back-end accountability. So of course, we can think of after harm has taken place, criminal accountability and civil liability. And so that, we're all sort of aware there are various ways in which the criminal and civil liability may be difficult to achieve in jurisdictions. And I'm curious to hear what our practitioners, esteemed panelists think about this, but institutional norms, political constraints, lack of political will with respect to bringing criminal charges, broad prosecutorial discretion invites the prosecutor to determine if there's evidence that can be proven beyond a reasonable doubt at trial. And perhaps we might see that as in some ways, in some jurisdictions, posing a barrier to back-end accountability. There is an institutional norm with respect to the way that grand juries are conducted. Again, I'll defer to counsel from Louisville to talk about that. But thinking about the grand jury as an institutional actor or body rather, that is sort of inherently lacking in transparency, and what barriers lack of transparency poses to seeking justice, and also along those lines and thinking about the Breonna Taylor case, the move by grand jurors to want to make public and go to court to make public the information regarding the evidence that they were presented in the grand jury, I think is an interesting sort of type of resistance in this moment, responding and pushing back against an institutional norm and practice that was sort of is rooted in secrecy. Qualified immunity, collective bargaining agreements, even the objective reasonableness standard under Graham, these are all sort of barriers that I can see as sort of built into the law's back-end response, whether we're talking criminal or civil liability. But to, again, expand the kind of conversation about thinking about accountability beyond just the civil and criminal accountability, I think what we're seeing also in this current moment is a type of political accountability. And so efforts by local community organizers and progressive groups to hold accountable district attorneys and mayors and police chiefs and hold them to task for their record on policing and what they have done, being sort of centered in local elections, community accountability. And so groups like We Charge Genocide in Chicago or Black Philly Radical Collective in particular, calling for reparations, Truth and Reconciliation Commissions as a type of community accountability to create not only an opportunity for airing grievances, but identifying pathways to repair with institutional actors, with local police, or contesting those groups. So a variety of different forms of accountability, very much rooted in local conditions, which I think our panelists, of course, will address as well. But I think to the broader question, and I'll close with this, can law be used as a tool to transform policing in America for the better? I think it depends on what account of policing you have. If we listen to abolitionist groups who are working to end policing through defunding as a pathway to abolition, or to radically reimagine the role of police in terms of achieving public safety to disrupt this coupling between police and public safety, they have a critical view that policing itself is rooted in a history of chattel slavery and border patrols and the dispossession of indigenous lands, and that it's impossible to remove the current modern form of policing from that context. It's impossible to transform policing if we see the institution of policing as irrevocably linked in many ways to these histories. If you move to more sort of progressive organizers and reformist accounts, there do, at least and certainly within the last several months, coming out of the protests against the George Floyd killing, and also, of course, Breonna Taylor's death, we do see at least an acknowledgement across a variety of political entities that the harms and benefits of policing have not been equally distributed. And so groups on the ground are targeting more transformative reforms like training and reducing the role of police, not only through budgets, but in a number of cities, redirecting 911 calls away from law enforcement, particularly in the case of mental crisis, and into 311 or into pathways that allow for mental health providers, let's say, to respond as opposed to law enforcement. So I point to the Cahoots example in Eugene, Oregon as an example of that. So, I think in this moment, there is an opportunity for law and lawyers to step up and support movements and victims of violence, seek redress. And I think that, many of the pathways to do so are currently being designed and developed. And I think if there's a moment and any source of optimism, it's in the innovation and the political will across the country to want to tackle this problem. So with that, I will turn it over to the next speaker.
Thank you so much, Professor Morgan. Attorney Gustafson.
Great. Thank you, Dean Nelson, Professor Morgan, other panelists, members of the community. It's good to be here today. So yeah, I'm Mike Gustafson. I'm with the U.S. Attorney's Office here in Connecticut. I'm a federal prosecutor. I've been doing it for over 20 years and work with police every day, work with federal agents every day. The vast majority of them are all-stars. They work hard and they come to work to serve and protect, as the saying goes. However, there are instances that our office has prosecuted officers criminally for violating the law, and we take that very serious as well. I want to talk today about one criminal statute that's on the book that we've used in several cases, talk about a few of those cases, and then talk about the civil component that goes along with the U.S. Attorney's Office oversight, a couple of tools in our toolbox, if you will. So the criminal statute is section 242 of Title 18, United States Code. And it's entitled Deprivation of Rights Under Color of Law. And what we would have to show, if we have prosecuted these cases, three things beyond a reasonable doubt, the elements of the crime. One is that the officer, he or she, acted under color of law. So in other words, they were acting in their official capacity. They might not have to be on duty, it could be off duty, but they have to be acting in a capacity that if they're a police officer, they're invoking that authority. So I guess an example would be, in the negative, would be if they were at a bar or a private party and got in a fight with someone over a personal matter. That would not be an example. But if an officer is on duty, they're acting under color of law. Second thing would be a deprivation of a right, guaranteed either by statute or the Constitution. And typically what you see most cases is the Fourth Amendment. Certainly protects people in their homes and their persons and to be secure. So if you have an excessive force case or unreasonable force, actually, as the Constitution says, or a false arrest or a false police report, or of someone's First Amendment rights to assemble peacefully, those would all be rights secured by the Constitution. And deprivation would then have us in the conversation as to whether the officer is liable under the statute. And then the last part, as a prosecutor, we have different standards of proof or mens rea, and this is willfulness. We have to show that the officer acted willfully. That'd be an act done with the specific intent to do what the law forbids, which is a little bit of a higher standard, but it's attainable. But it is, I think, in cases that are unsuccessfully prosecuted or cases that are not brought, that's where the prosecutor's discretion, that's where the focus is going to be when trying to figure out whether to exercise his or her discretion to bring that indictment, whether the act was willful or not. And this statute, section 242, it applies, I'm talking about police officers, but applies to all public officials, prison guards, and any other public official who would have the authority to impact someone's rights. So a couple of cases, just real briefly. I prosecuted one, we had one in Meriden where an officer actually was I think the son of the chief of police. And it was well, I guess we'd call it a one-off case. It was a single incident. It was not a pattern or a practice, but it was a drunk individual who was in a car accident, uninsured, was at a house party, which the neighbors were calling in. So not a particularly sympathetic victim, but nonetheless a victim, because the officer and this individual who was gotten hit a tree because he was so drunk, probably weighed 90 pounds. And the officer, of course, weighed a couple hundred pounds. And the booking video at the police department showed the officer take the individual, put him in a cell, but he shoved him and threw him up against the wall. And it was a cement wall and a cement bench. And the individual hurt his head. The officer came back and saw the individual on the floor, called 911 at that point, and then ginned up a police report that had basically was fiction, had nothing to do with really what had happened. And so that was the case, was on film, and we successfully prosecuted it. A case I unsuccessfully prosecuted, which was also on film, was an individual, three officers, two of whom pled guilty. The third was seen getting out of his cruiser, coming up to an individual who was handcuffed on the ground and picking his foot up to step on his head. And this was a civilian, had a video clip of it. And the video cut off right before the individual was kicked in the head. But a jury just didn't see it our way. And I apologize. Do I have 1 minute left, or is that from the prior? Because time flies, and I apologize if I'm killing it. Let me just talk about the main one I want to talk about, which is the East Haven Police Department. In that case, there was 4 officers, and they were essentially running wild in East Haven, trampling on the rights of an immigrant community. A lot of false arrests, car stops, tossing the car, some illegal searches at some of the businesses they owned, and just in general making this community's life miserable. We have radio transmissions where the officers became saying stupid things to each other that was helpfully captured on tape. We had the accounts of various individuals as well. We had a priest in the neighborhood who's working with the individuals who videotaped the officers inside a store one night as they were tossing the store, and the videotape, which captured everything on tape. The officer said, "What's that you got in your hand? You're not videotaping me." And he came over and he ripped the camera away from the priest. His police report talked about the priest was ducking behind the shelves and he had a silver object that could be a gun. And this officer feared for his safety and, confiscated the camera. Well, the film obviously had the officer saying, "Put that camera down, you're not videotaping me." So things like that went a long way to successfully bringing a prosecution. In that case, 2 officers went to trial. They were convicted. The sentences in the case, there was not a lot of excessive force. It was mostly, I say not excessive force, it was not a lot of instances of alleged allegations of force. It was all false arrest and the harassment type activity. But the officers went to trial, were sentenced to 60 months, 5 years, and the other one received 2.5 years. The ones who pled guilty got 24 months and 4 months. So the judge understood how serious this was. I bring this up because the other piece of that case was a civil component, and I'll wrap up at this point. But the Department of Justice did come in, did a very thorough investigation, asked a lot of questions, and with the threat of litigation, a civil lawsuit pending, got the city, the municipal authorities, the chief of police to the table and negotiated a consent decree. East Haven didn't want to call it a consent decree, so we said, fine, we'll call it a settlement agreement for constitutional improvements. Rebranded the consent decree, but it had all kinds of hiring, training, discipline reforms. There's benchmarks to be met along the way, 6 months, 1 year, 18 months. And the department really turned over a new leaf. A lot of the bad apples left the department and a new culture was instituted. We had a monitor was appointed by the court who was internationally recognized as being very progressive police chief. So after 3 years, frankly, the department asked to get out of the consent decree, and the government agreed. And it culminated with, because of the improvements, and it culminated with Attorney General Loretta Lynch coming to town, meeting with the officers and also the citizens. And I think that's a really good example of, leading the exam in life and having some assistance from the Department of Justice in a pattern or practice investigation. So I've gone far too long, so I apologize, but thank you.
Thank you so much, Attorney Gustafson. And as we turn to Professor Miller, I just want to encourage the attendees to please submit your questions via the chat so that we can have a very interactive discussion following the presentations. Thank you. Professor Miller.
I'd like to thank my former colleague, Dean Eboni Nelson, for inviting me to this panel. And I'd like to thank the attorneys who will follow me for allowing my students and me to provide some assistance to them in the Breonna Taylor case. My thesis today is that what we're talking about, police shootings of people of color, can't expect vindication and justice in the courts based upon 2 existing developments in the law, and that it has to be grassroots, on the ground, local legislation that addresses these issues. The way I became involved in the Breonna Taylor case was actually a case heard in oral arguments in the Supreme Court yesterday, the Roxanne Torres case. Roxanne Torres lived in an apartment complex in Albuquerque, New Mexico. Police came to execute an arrest warrant for someone completely unconnected to Roxanne Torres. She sees the police approaching. She jumps in her FJ Cruiser. She starts driving away. They shoot at her 13 times, striking her twice in the back. Roxanne Torres is able to drive away, eventually go to a hospital and get treatment. She sues the officers for excessive force to the point that Attorney Gustafson was talking about a second ago. And the response in a motion for summary judgment is you can only have an excessive force claim if there's a seizure under the Fourth Amendment. And the district court and the 10th Circuit agree and find there's not a seizure unless there's a cessation of movement or physical control over a person by the police. And so we argue to the contrary that, of course, this is a case where excessive force should be on the table. Police shot an innocent woman twice, firing 13 bullets. And you might have expected in oral arguments yesterday to have discussions about everything going on in the real world today, including the Breonna Taylor case. In fact, in the confirmation hearings, you might have heard Senator Klobuchar asking Amy Coney Barrett about whether she takes the real world impact of cases into account in deciding cases. But if you listen to the oral arguments, it wasn't about that. It was about Dickensian era debt collection. And back in 17th century England, what was the definition of an arrest / a seizure? That's what the Fourth Amendment has become today in our judicial system. It's not about the real world consequences. It's about what the founders meant at the time they wrote the Constitution. And what it means is, even if the court agrees with us that this was a seizure, we still have a second hurdle that's faced by a litigant such as Ms. Torres, and Professor Morgan mentioned this earlier. That's the doctrine of qualified immunity. Qualified immunity, the legal standard is essentially an officer, a police officer, can't be held accountable unless they violated clearly established statutory or constitutional rights of which a reasonable person would have known. On its face, that doesn't sound unreasonable. In practice, what it means is, unless a court has previously found the exact behavior that police officers engaged in violated constitutional rights, it's qualified immunity, and the person who is injured is not going to recover. We had a cert petition in a case, Jessup versus City of Fresno. The Supreme Court denied cert. That involved police officers executing a search warrant, allegedly stealing money from the suspects. They brought a Fourth Amendment action against the officers, and the court found qualified immunity. There's never been a case where police have stolen money and that has been found to be a Fourth Amendment violation. Think about the consequences of that in a police shooting case. And that takes us to the Breonna Taylor case. When my students and I reached out to the attorneys who will follow me to offer assistance in this case, part of our research dealt with no-knock warrants. And we have these questions in the presidential debates about whether we have structural racism in our society and policing, and the statistics bear it out. A Denver Post study found 82% of no-knock warrants were against people of color. A KATV study out of Little Rock, Arkansas found 67% Black males, 15% Black females were targeted by no-knock warrants. Obviously, the Breonna Taylor case resulted in a shooting. It never should have been a no-knock warrant, let alone a warrant in the first place. That likely wouldn't have been enough. If it was just a no-knock warrant and the police firing all these bullets and shooting Breonna Taylor, the attorneys after me can speak in more detail, or maybe they can't because it's settlement, but that probably wouldn't have been enough. Qualified immunity in our research would have protected the officers. It was the happy circumstance, quote unquote, happy, unhappy here, that there was a material lie in the affidavit for the search warrants that they had spoken to a postal inspector about the ex-boyfriend getting packages at Breonna Taylor's place that I think facilitated the settlements. Breonna Taylor's case has led to bans on no-knock warrants. That's what's going to be effective. Several states, including Connecticut, have started banning or limiting qualified immunity. That's the way we have reform. The current court system is not sufficient.
Thank you so much, Professor Miller. Next, we'll hear from Attorney Baker. And again, I encourage you to continue to send in your questions. Thank you. Attorney Baker.
Thank you. As you were reading my bio, I realized that in an attempt to shorten the bio, I cut out a good chunk of my legal experience, which before I became a prosecutor, I actually worked as a public defender as well. So I've worked on both sides of the criminal law system. And then also as a legislative advisor for the city of Louisville prior to working with Sam at Aguiar Andrew Lawyers. And that experience has given me a unique perspective into the criminal justice system, both from the criminal prosecutorial side as well as the civil remedies, as Attorney Gustafson said. Without going too much into some of the things that have gone on, have already been touched on, I do want to talk about, the roles and where do we go from here, because one of the things that as in representing the family of Breonna Taylor that was important to both Sam and myself and our co-counsel Ben Crump was it's not enough just to get a settlement in this case, right? What can we do to prevent this from happening to other people? That was not only important to us, it was also important to Breonna Taylor, which is why when you saw our settlement, which was the largest settlement in Louisville Metro government history, but it was also unique in the sense that it had police reform included in the settlement. Because until we start changing laws and policies, and I always say, I hate the word policy because policies can be changed, up or down. I want laws changed, because only then will we truly begin to eliminate some of the systemic issues that we have within the criminal justice system. Right now, it is too hard to hold officers accountable. That's partly due to the laws that are in place, but it's also a lot to do with the union contracts that are in place. And that's something that we definitely have to talk about in this discussion. And so until we change those things, though, we're going to continue to have, if officers can't be held accountable, what's to stop them from shooting someone else? One of the things that Attorney Morgan said, Professor Morgan stated, was that it's now is a good opportunity for attorneys to get involved in the activism. I say we have to, it's necessary that we get involved. In our case, we relied a lot on the activists because the only way to counter the power of police unions is to get the power of the people out there and for elected leaders to see, oh shoot, this isn't just the attorneys, this isn't just the family that's fighting us here. Like they have a ton of support within the city of Louisville, and eventually those elected leaders they begin to count votes. And so that's how you can really push through change. And also to Attorney Gustafson's report, I do want to make sure people know, because there is still a federal investigation going on with Breonna Taylor, and we definitely hope that the FBI and the Department of Justice attorneys that are involved in that case do bring forth charges, criminal, constitutional rights violations on the officers, both criminal. The only thing now is, under the current federal administration, they're not doing consent decrees as much as they would have or were doing them under the last presidential administration. So that's one of those things that, I always talk about when we're talking about elections, and elections have consequences. We have to think about it's not just these issues. When you talk about, are we doing consent decrees? No. Who's appointing police chiefs? So it's so many things that, I hope we talk through today, but consent decrees, they're not doing them right now. Louisville Metro Police Department, based on a lot of issues that they've had over the past few years, we had the Explore child sex abuse case. We had last year, they were doing 2 years ago, the illegal search and seizures. This is a prime department that would be subject to the federal government come in, doing an evaluation and issuing consent decrees for the police department to change. And I do want to say, we do have the criminal and civil, and when we talk about it, Sam and I represented them on the civil side. We're heavily involved in seeking criminal justice for our cases. For most of the families involved in these cases, it's not about the money. They could care less about the money. It won't bring back their loved one. But what we've come to find out, and what we know is the financial penalty, and usually only that financial penalty, or the risk of a financial penalty, that's going to kick cities into action to actually put forth change. So that's all I'll say, and then I'll look forward to the Q&A session.
Thank you so much, Attorney Baker. Attorney Aguiar?
Yeah, hi, everybody, and thanks so much for having me today. Really nice group of folks here, and being able to talk about this is great. It's been a heavy focus in my practice over the past several years, and I think it's so important today because I think that this generation of law students is critical. I see a dynamic shift in terms of the way the world is going with that generation of folks, non-traditional too, but definitely with the folks that are in their 20s right now. You don't need a law degree to get change. So what can you do right now as a law student? Well, first and foremost, one thing I've learned is that it can't be work, it has to be passion. So before you just go out and say, well, I'm going to end systemic racism and police bias, you need to deep dive and you need to figure out what your passion is, what you really want to see change, what's going to be pleasurable for you. But you can't make that change without knowledge. So I want you all to know right now that there's this big movement going on, but until you see what the root cause of the problems are yourself, it's really tough to make substantive change. So get together. You have to do research. And I put together what I think would be at least my model. If I was in law school and I had some buddies and I wanted to make some change now and really feel like I was part of the movement, I would divide and conquer. One individual, you need to learn police culture before you can make police change. And the way you learn police culture, first and foremost, is you got to build alliances in the police department, and you need to talk to them. So get a person to be their friend, see what they want, do police ride-alongs, learn what it's like to be a cop, learn the culture. Just on an aside, if you're in a jurisdiction with body camera footage, get footage from normal interactions. That's open records. So as opposed to just going out and getting the body camera footage that everybody sees TV from, egregious actions, get some from traffic stops. Get some from friends and family that you see, and don't look like you're trying to implicate the police. See what an actual law enforcement interaction looks like. Speak with those that investigate the police. Figure out what they're doing in those situations. The next volunteer, next part of the group I would get is to actually get into your community. Have one of you go out, start volunteering in the communities that are subject to more biased policing, whatever the data suggests, the most impoverished communities, the Black communities. Get in there and actually talk to people, volunteer, see what these folks want. Because if you're going to go out and fight for change, you need to make sure that it's going to be the change that people are going to rally behind. Then you need to go out and actually get together and see what the problems are, not just from the community, not just from the police discussions, but go and get the data. One of the things that we've been able to do through open records requests is actually look at how many, look at the racial disparity between police stops, to look and see what the frequency is, to look and see what, how many internal investigations are open against officers versus how many result in exoneration and unfounded allegations. Look at the actual police policies and procedures, and that's all public. And the last thing I would recommend that you actually go out and get a person to do is figure out what the laws and the policies are. You have wonderful law professors. Sit down with them. Learn what the laws are right now in your jurisdiction across the country. Identify the ones that need to be changed and see if they need to be changed at the legislative level or the court system. And at that point, all of you can get together, determine what needs to be changed, see what reform has been passed in other areas. Does it work? Speak with those who actually crafted those changes. How did they make it happen? But also speak with the ones who crafted the changes that you went back and saw didn't work. What would they do differently? And make sure you go out and learn your legislators. Legislators right now, unfortunately, they make a lot of momentum and popularity plays, but you need to actually use that to your advantage. See which legislators want some clout. See who's going to fight for you. See who wants to make a name for themselves. See the ones that have gone up and presented similar legislation that's passed. Find out who your opposition is going to be. You always need to learn your opposition. So who's presented things and actually had other folks get up in a caucus and say, no, that's not going to happen. Who donates to the campaigns? You need to know that because you need to know who actually is going to be when you look at and see who donates to a legislator's campaign, unfortunately, you're going to see a lot of the plays that a legislator is going to make to assure that they keep getting those donations. I'm talking too much, but make sure then you get to the point where you gather support, see who has a powerful voice. I'll remind you that Breonna Taylor's case specifically, a change.org petition has 12 million signatures. It's the second most ever. It was created by a law student. So just remember right now, if you sit here and think, all right, this is going to be great when I become a lawyer, I'm going to be able to go out and fight. No, you can go out and fight right now. So much of this change that needs to happen can come from each and every one of you. So I had more, but I'm talking too much. So let's get rolling with some questions. But I could talk about this all day.
Thank you so much, Attorney Aguiar, for those very thought-provoking comments. And thank you so much to all of our panelists for your wonderful remarks. So getting to the questions, one of the questions we have is with regards to qualified immunity. And the question is this: if qualified immunity only allows reprimand for behavior that's already been condemned, how do we start? How do we get to the first step of establishing that something is unacceptable? What behavior has already been established as unprotected by qualified immunity? Would you like to start with that, Attorney Gustafson?
Sure. Yeah, it's a real problem in the civil world, civil lawsuits. I've got a citation. I can put it up in the chat, but I'll just read it out because I actually pulled this case up in anticipation. It's a district court case out of Mississippi from August. The site is 2020 Westlaw 4497723. I'll put the chat up. But in that case, the judge granted qualified immunity and on behalf of the officer, and he points out all of the cases heretofore that, something that seemingly was obvious to everyone was a matter for qualified immunity. And I know that I think it was Professor Miller talking about it as well. It's a real problem for civil litigants to get past that doctrine. In Connecticut, the General Assembly just passed a statute, Police Accountability Act this past spring. And in there, they have a statute that's analogous to the civil rights lawsuit, Title 42, Section 1983. And they've specifically tried to define qualified immunity in a way that, while it certainly will protect law enforcement officers from liability in certain instances, it does not have the expansive effect that the federal doctrine does, which was judicially created. So I don't know if I have a good answer for how we can get how qualified immunity is going to change, but it's absolutely something that the courts have taken to a level where it has to be an obvious right that the officer should have known about, as opposed to a more specific inquiry of, well, can you use excessive force or not? The answer is no, you can't. The Constitution forbids it. Did you use excessive force in that case? But I'll put that citation up now.
Thank you. Anyone else like to respond on the issue of qualified immunity? Yes, Attorney Aguiar.
So qualified immunity, I guess let's just start real quickly. It's very intimidating for baby lawyers. It's very intimidating for folks in law school. One thing to remember is that qualified immunity, the way to make sure that it doesn't become something that you're up against, is to take the decision out of the officer's hands. As soon as something becomes mandatory, they can't say, oh, well, I had discretion. I made a bad decision. So when you look at statutes, when you look at police policies, look for language like should or recommendation or may, and fight to replace those to shall, required, things along those lines, because the millisecond you take that decision out of the officer's hands, they do not have qualified immunity. So, for example, if you've got, a police pursuit policy, and police pursuits are very dangerous. The research on that, again, we could talk about all day. And you look and you say that, the officer should take the following factors into consideration. Or if you've got a policy that says you shouldn't pursue somebody if the only suspected offense is a misdemeanor, okay, they still have some discretion right there. But if that policy is changed and you say you cannot pursue somebody if the only suspected offense is a misdemeanor, or if they've not been involved in a violent felony, or you cannot, pursue somebody that is, in a stolen vehicle only, then all of a sudden, you've beaten qualified immunity in a situation like that. So I know that we could look at all this case law, see some questions coming in, but to simplify it, take the decision out of the officer's hands. Remember that even police department policies are satisfactory to impose a known obligation upon an officer, and that will defeat qualified immunity. So again, just keep that in mind when you're coming up with your policies, your procedures. As soon as you see some language that leaves wiggle room, fight against it.
Thank you so much. Another question that's been raised is having to do with just the structural racism and institutional racism that we see in the criminal justice system. So can our society and the Black community specifically obtain justice when there is still an emphasis on the meanings of the Fourth Amendment, when Black Americans were not treated equally as white Americans? How can all races receive justice when our laws were written at such a different time in our country's history? Professor Morgan, would you like to start that?
That's a very difficult question. I think in so many ways, we are dealing with a legal regime that, as the questioner points to, was created during a period when, Black people were considered 3/5 of a person. And so I think that, that's sort of a cynical account but a realistic account in terms of like the origins of the law in this period of widespread dehumanization for so many of us. But I think at the same time, again, turning to a point of optimism, I see that there's, whether it's through cell phone videos, activists, both on social media and in communities, just shedding light on the experiences of policing for so many communities across America. And I think that's now centered more in our national conversation than it has been before. And I think that, as my co-panelist said, that there's obviously limits to and barriers to legal reform, but so much of the activity can happen at the legislative level, policy reform and legislative proposals, and pushing our local officials and elected leaders to respond to the problems of policing, and doing so and I think in a way of really getting at the heart of it and promoting public safety for all and ensuring that community safety is achieved. And again, there are communities that don't see the police as central to that, and there's communities that do. And so we can't just paint with one broad brush and say that, we should, pursue this particular path as a way to ending police violence. So, I agree with a lot of what Attorney Aguiar said. It's so much, and Attorney Baker, so much of this has to come from rooting oneself in a local community and understanding the pathways to change in that. The law can't be centered in that all the time, or I guess I mean traditionally the courts can't be centered as a reform project, even as a reform project, because that's where we'll encounter barriers. A lot of this is going to come from changing hearts and minds and getting voters to try to tackle the problems of policing through legislative reform.
No, and the Fourth Amendment itself is necessary. Like, we don't want to be, people to be able to infringe on our right to be free from searches, to come into our homes, unjust without probable cause. It's not the Fourth Amendment itself, it's the way that the Fourth Amendment has been implemented and the actors who are implementing the Fourth Amendment. And it's warrantless searches, right? So you take the case of Breonna Taylor, they actually had a search warrant. It was just, it had a lie in it. So it's not, that wasn't the Fourth Amendment that caused Breonna's death. It was the actors in the case that lied to secure a search warrant to go into her home. So it's still, we have to focus on how do we hold people accountable when they do violate our laws. So I do think that the Fourth Amendment itself is not the issue. It's the way that it's implemented. And as Professor Morgan just stated too, it's changing the minds of people. And I do think that with body camera, with cell phone cameras, because a lot of times what we're seeing is body cameras are being turned off when officers are engaged in acts they should not be engaged in. But with people recording things by cell phone, with people having security cameras, we're in a time where in 2006, when I first started practicing law, what the officer said was controlling. Right? I was using flip phones, I think, when I came out of law school. So what the officer said was still controlling. It was not. Now you ask 10 people, do you believe the officer or the person that they've accused of something? And you're going to get different. They're not just believing the officer's accountability or the officer's account of what happened. And so that's what we need to change is we need more transparency. I think that one thing that is necessary is the mandatory activation of body cameras. Everyone should have them. I get there's some circumstances, talking to an informant, or maybe deep undercover where you would not have them. But I do think that the mandatory activation, we used to say mandatory use of body cameras, but what we realized is saying use, they have them on, but they never turn them on. So we have to actually activate the body cameras. Body cameras were coming around during my last couple of years as a prosecutor, and it was the greatest tool on earth for me. I was like, it's right there as a prosecutor. It's either they did it or, I think that's one of the legislative pieces that we have to push. And at some point, if officers are not activating their body cameras, there has to be accountability for them not activating the body cameras. So it's not the Fourth Amendment, but just the actors and changing the perception of America as it relates to policing.
Thanks, Attorney Baker. I agree 100% with you. I know certainly my reaction now with body cameras, I think actually a lot of law enforcement is okay with it. I think, the hue and cry when it first came up was, this is horrible. I think a lot of times it shows them when they do a good job, or it shows how hard the job to do is, or as a prosecutor, they come in and I say, you got the camera. I wasn't in my AV club in high school, but that's pretty much all you had to do. Now to be a prosecutor is roll the tape. If it's there, it's great. And when it's not, I have a real hard time saying we're going to go forward with the case, just because you're right. Juries and people expect that it'll be on. If it's not, well, why didn't you have it on? You better have a really, really good excuse for not having it on. And the other thing you mentioned earlier was no-knock warrants. I've had some conversations with a lot of law enforcement, and interestingly, it's the chiefs of police and the more senior law enforcement who I think they get it. And no-knock warrants are just dangerous, obviously, for everybody. But I think the time has come when a lot of law enforcement are reevaluating whether that should be in the playbook or in the toolbox or not. So maybe going forward, we'll not see we'll see that being eliminated from policing.
Thank you so much. This next question, Professor Miller, I would love your thoughts on, as one of the co-hosts for Undisclosed and the great work that you've done there, as well as your discussion about the need for this grassroots movement. One of the other questions that was raised with regards to the role of the media, and I would stretch that to be social media. What role do you think that media coverage and social media coverage can both help and perhaps hurt the cause of advancing criminal justice reform?
Yeah, so on my end, luckily to this point, it's been tremendously helpful. The whole purpose of the podcast is to work with innocence projects and attorneys on people's cases we believe are wrongfully convicted. And we use our platform to get our listeners to reach out to conviction integrity units, to reach out to governors in cases of impending executions. There's a case currently pending, the Purvis Payne case out of Tennessee, where his execution is scheduled for December 3rd. He's an African-American man who says, I came upon the stabbed body of a Caucasian woman, and I was afraid, I ran away. He had no criminal record. He has intellectual disability. He's seeking DNA testing, and his execution is scheduled for December 3rd. Part of what we're doing now is a social media calling campaign to get the governor there to stay that execution. We've had 2 prior instances where calling campaigns have helped to stay executions. And as you mentioned in the introduction, we've had 9 of our quote unquote clients on the podcast be exonerated. And so I think there's a tremendous upside. I think that whether it is pragmatic or whether it's sincere, that local officials are responsive when they get their phones blown up and their email inboxes filled by people who are saying, here's a case, here's a bill we support, that they are in fact responsive. There's a potential downside. The potential downside is that the legislator, the person who can make the decision, is turned off by the coverage. And that's why I think it's important to be balanced and truthful and make sure you're presenting an accurate case, because if they get the sense that you're presenting a biased position and not telling the public all the facts, that's where they might get defensive and not move forward. But I think that the media and social media and the public out there, especially in the Breonna Taylor case, we obviously have seen can be tremendously effective in implementing change.
Thank you, Professor Miller. Anyone like to add to that? Great. So another question that we've gotten, we've been hearing about several different reform ideas And so we have a question that's a little bit more specific, and that is, what is the single most important change we need to be advocating for right now that seems the most achievable and would have that impact of bringing about real change that we all want to see? So they're making you narrow it down a little bit. In your opinion, the single most important change to be advocating for right now?
For me, I think, well, there's two, but for me, mandatory body camera activation. I think that's easy, it's attainable, it should be happening, and it will help to eliminate a lot of the issue. If it's on camera, and you're going to be penalized if you don't have your body camera activated, it's going to eliminate a lot of the bad behavior that we see as a result of not having them on.
Thank you. Anyone else? Professor Morgan, what would you say if you had to narrow it down to the single most important?
So like Attorney Baker, I also have two in mind, decriminalization and diversion. So thinking about, the vast majority of individuals, getting swept up through quality of life policing or order maintenance policing as not necessarily posing a risk of harm. And so getting them the treatment that they need if there's a underlying mental disability, getting them access to housing if they're in public space because they don't have access to housing and care. So decriminalization as a way to kind of remove pathways into police encounters and to if we're thinking of a regime where we rely on police for public safety, reducing the police role. So we ask police to do so much in society. And I'm thinking of jurisdictions where the calls for quote unquote emotionally disturbed persons comprise the vast majority in some precincts of the police work that's happening. What would it look like to actually provide mental health care and provision in communities so that police aren't responding to these accounts as well? So those two things, I think, if I were to think of sort of transformative reforms to really tackle this problem head on and on the front end. So we're not looking at back end accountability measures.
Thank you, Professor Morgan. Anyone else like to give their one or two single most? Okay, we also had a question that's very, very direct with regards to what was the false statement in the affidavit requesting the search warrant for Breonna Taylor's apartment. So someone wanted to know exactly what was that false statement. And related to that, also if we could talk about police culture and the fact that there was this false statement that was included. What does that say about police culture and ways for us to see about improving that so that we don't have those type of false statements happening in the future? Attorney Aguiar, would you like to handle that?
Sure. As far as the false statement, we're all good. I posted the response in the chat, so she got it. So we're good there. So if everybody just pulls up the chat, it's actually got that in there. As far as the culture, I think that we can't be naive here. This wasn't an isolated incident. This isn't the one time that some officer went and completed an affidavit for a search warrant that contained false information. The only reason that this became public is because of the tragedy and the death of Breonna Taylor. So until we can get to a point where there's folks that can go in and actually review these search warrants, and can review assertions that police are making in support of probable cause to see exactly how systemic it is and how pervasive it is. The public's going to keep looking at this with, and the police department's going to try to make the public look at this with a narrow view, as in this is one bad apple. The feds are going to look into them. They're going to hold people accountable. And then thank God the rest of everybody else that fills out these affidavits wouldn't dare do something like this. When I think if we sat down today, again, it is public record. A group of law students could certainly go in, pull all the search warrants, divide and conquer, and look at these assertions. Because when you look at the Breonna Taylor case specifically, what the documents reveal is that this language was cut and paste, and it had actually been used as the basis to obtain other search warrants. So this wasn't just an isolated statement on one search warrant. He actually had used this falsified probable cause assertion about a postal inspector and what he observed and what he advised them on several occasions. So, the one thing I look at is that maybe is a decent playbook. Every once in a while, you have the Department of Justice come in and intervene. They did so in Chicago and wrote a scathing report. They did so in Baltimore and wrote a scathing report. And if we can get some independent bodies that can come in and actually look at these departments and, gut them and look at all of these things, that's what reveals the cultural issues, the systemic problems, and really educates people, because one of the things that we're running into with Breonna Taylor is every day it's something new. So the public never gets the full picture. And you hear one thing and you're like, wow, this is a corrupt department. Then you hear the other thing. But if you could just get a scathing, comprehensive review, I think you need to know the full truth before you can fix it.
And to add to what Sam said is, the reason this should matter to the law and order folks, because I want to make sure that people know this isn't an anti-police campaign or anything like that. What I can think of with my former colleagues that are still prosecutors and, those who work with Attorney Gustafson is, I guarantee you that there will be a number of defense attorneys, a number of former defendants who have been convicted or pled guilty based on search warrants written by the detective in the Breonna Taylor case, who are going to ask for their cases to be reviewed, to be overturned, to get those guilty pleas set aside. So then you are potentially allowing dangerous individuals back out of custody because of the actions of this officer. And so we don't want that to happen. So that's why we have to fix systemic issues like this. And I mean, because it is going to open the floodgates, and the only unit that can be blamed for that is LMPD for not catching things like that and not having any parameters in place to prevent behavior like that.
Thank you so much to you both. This question, Attorney Gustafson, might be best directed to you regarding the recent Connecticut Police Accountability Bill, as it's being called. Did it do enough? Where did it fall short? And to what extent is it substantive? And to what extent is it simply political theater?
Yes to all that. So let's see. So I guess the first disclaimer is, as a federal prosecutor, it's not going to affect me. It's not going to control what I do. I have looked at it, so I have enough information, I suppose, to be dangerous. I think on the portion where it allows for a civil suit against a police officer, I think that is very analogous to the federal statute, Section 1983, which we mentioned a moment ago. And it, I think, gives another cause of action for a citizen who's aggrieved by a police misconduct. It only pertains to police. It doesn't cover other government officials. And the qualified immunity language in there seems to be an attempt to narrow it from what the federal qualified immunity doctrine has become. And I think only time will tell if our courts in Connecticut interpret the Connecticut statute more narrowly with respect to qualified immunity. I think the statute also doesn't allow for interlocutory appeals in a denial of a qualified immunity. So in other words, if an officer sought to get out of a case on qualified immunity under the state statute, the Accountability Act, and that was denied, the officer would not be able to take an immediate interlocutory appeal, but would rather have to litigate the rest of the case, which is interesting because I think in the federal system, if it's a question of law, you'll get an interlocutory appeal. The other aspects of the bill, which I think will have more sweeping effects, are certainly the notion of a consent search. As a prosecutor, oftentimes you hear about a gun or drugs that were found in the car because the operator of the car consented to the search of the car. And then there's always a challenge of, no, I didn't. And the officer says, yes, I did. With the body cams, oftentimes it's on tape, and you can see how artful the conversation was manipulated by the officer or inartfully manipulated by the officer, or hopefully it happened to some extent, because then the search, you can get into the facts of whether it was a constitutionally permissible voluntary search. In Connecticut, the law is is talking, or does take away, it has taken away, become effective already, consent searches. So you can say, I consent to the search of my car, and it's not valid in Connecticut, which is a big change, because oftentimes these traffic stops happen with the hope by law enforcement that they're going to find contraband or something in the car. And when they don't, obviously, you've got a bad interaction between law enforcement and a member of the community. So I think that's, I guess, the more I think about it, I haven't read the whole bill, but the more I think about it, the big game changer would be the fact that there's no longer consent to search in the state. And the other one, which I don't know enough about, but I know it's in the bill, is a duty by other officers to come forward if they see something wrong. They will be liable under the bill, but I don't have the exact language in front of me, but I know there's certainly a mandated reporting by the officers if they see someone else, one of their colleagues, doing something wrong.
Thank you for that. Professor Morgan, I wondered if you had any thoughts to share as well, since I know you were working and helping with regards to that this summer.
Oh, actually, I wasn't a part of the team, but I would shout out like many of my colleagues at the law school for, working and supporting the groups that were a part of that legislative. So it's a collaboration for sure.
Yeah, thank you. Thank you for that. So we're running out of time for today's discussion, but I, would just perhaps ask for just a very brief response from all of you for a final question of really, how do we seize this moment? Obviously, there have been shootings and police violence for decades, centuries, but there seems to be something different about this moment. Very quickly, how would you advise us to seize this particular moment so that we really do see the change that we all are fighting for? We'll just kind of go down the list. So we'll start with Professor Morgan.
Sure. Just again, would really encourage you all, whether you're, currently in law school or a practitioner, to dive into this issue, issue as it relates to policing, understand the local laws, understand where activists in your communities see the issue and how they pose a problem, understand the police department policies. So really becoming more engaged, I think, is the first step. And then I think that will give everyone a better sense of how best to plug in if this is an issue that you do want to plug into.
Thank you. Attorney Gustafson?
Sure, thanks. I'll probably steal some of Sam's thunder because I loved his opening comments a lot. I think, get involved. There's different ways. The ride-along programs, a lot of departments have those. A body camera, he said, pull body camera footage. It's available. That's good stuff. So you get to see what's happening on the streets, good, the bad, and the ugly. Volunteering clinics, certainly the law school's got a number of clinics that are very helpful for experience. Here at the U.S. Attorney's Office, I teach at the law school, we have the Civil Rights Clinic. And that's a great way to see what the U.S. Attorney's Office does to enforce various civil rights, not only in policing and civil rights, but also housing and religious issues and disability, things like that as well. So those opportunities are there at the law school too.
Thank you so much. Professor Miller?
Yeah, well, I assume that Connecticut is not dissimilar from South Carolina, and that probably a lot of your state representatives are graduates of the law school. What I've done with many of my students is to reach out to our local representatives, again, many of them grads of the school, and propose legislation and have the student body be supportive. And so, another case we haven't mentioned is the Ahmaud Arbery case in Georgia, which goes to antiquated racist citizens arrest laws. And so one of the efforts in this state is we're trying to ban citizens arrest, or at least modify it in South Carolina. And so, if you can partner up with your professors and reach out to their former students who are now representatives to really push a comprehensive package to address all these different issues beyond the ones we've addressed today, now is the time, as Dean Nelson noted. And I think it's a moment where people will be very responsive to those types of efforts.
Thank you so much, Professor Miller. Attorney Baker?
Yes, I am going to close in the famous words of Charles Hamilton Houston in that a lawyer is either a social engineer or a parasite on society. And I'm going to encourage everyone, law students, young lawyers, corporate lawyers, whoever, lawyers, we have to be the social engineers. The grassroots activists are out there. They can't do it alone. They need lawyers to be there to help. And I know Sam says you don't have to be a lawyer to write legislation. You don't, but you have to be a lawyer, or you have to have some legal training to be able to really know what does it mean, what shall, may, those things. And so that's where we need to be involved. The activists are doing their part. It's time for lawyers to step up and do our part.
Thank you so much, Attorney Baker. Attorney Aguiar.
Yeah, let's wrap up. Like you said, there is a movement right now. It's a damn shame that we're such a momentum-driven society, but it's a good thing, at least right now, that the momentum is in our favor. One of the things that we haven't talked about that hopefully everybody will get together and start really working on is what is the end game for this movement. And one of the things is getting rid of the bad apples. Make sure you see how hard it is right now to get rid of bad police officers, and let's fight to make it easier. But you never get to a point of bad police officers if they're trained and indoctrinated and recruited correctly to be good police officers. So let's make sure we're working on that as well. And let's get rid of this us versus them mentality. The sooner that we can get together and get rid of that blue line where all these officers keep protecting each other at the expense of the public and withholding information, and the sooner that we can realize that they're going to do that, but in exchange, we have our obligations to forgive and move forward. Maybe we can actually make this world a better place. I'm counting on this generation of law students. I think they're going to make it happen.
Thank you so much, Attorney Aguiar. I couldn't agree more. The faith that we have in the momentum right now and in the young law students and in the young attorneys, and again, all attorneys and everyone who is working on these issues, whether you're an attorney or not, I have great faith in real change coming about. And so I want to thank you all again, all of our distinguished panelists, for your participation today. Also want to thank all of the attendees. Thank you so much for attending today. And of course, I want to thank Allison Swain, Tracy Siegel, Deb King, and Jean LeBlanc for all of their great assistance in bringing us all together today. Thanks again to our co-sponsors and our supporters. This is such an important conversation, such an important topic. I'm glad to see all of you engaged in it, and I thank you all for your commitment and passion and your dedication to this important work. It was my honor to serve as your moderator, and I thank you all again for attending and participating. Have a great day.